You know me, I'm Bart Hildreth from the Andrew Young School at Georgia State. The panel today is on the Municipal Securities Rulemaking Board at 40. That is, it was created in 1975 to protect investors by promoting a fair and efficient municipal securities market. The MSRB fulfills that mission by regulating the municipal securities firms, banks, and since the Dodd-Frank Act, municipal advisors, and protecting issuers and the state and local governments and other municipal entities. Part of that protection is through the disclosure of trades through what we all know is EMA, official repository for information on all municipal bonds. The beauty of the panel today is that we have two of the three executive directors. There was an initial executive director for the first 2 years. And I'll introduce each of them. We have a long-standing observer, participant in the market from various different roles in the market. And we're honored to have today the investor advocate for the Securities and Exchange Commission to talk about, from that office's standpoint, from his standpoint, the municipal securities market. So what I've asked them to do is to give a 5 or 10 minute set of initial comments. I've given a few questions that we might use to start some dialogue, but then we hope to have you ask questions as we move through the session. So the first speaker will be Dr. Christopher Kit Taylor. Kit served as the second executive director, but for a very long term, from 1978 to 2007, where he pioneered a lot of the regulatory schemes we now know exist for the municipal securities market, including yield disclosure on customer confirmations, automated clearance and settlement of trades, worked on the collection and dissemination of issuer disclosures in the primary and secondary market, rules banning political contributions by municipal finance broker-dealers, and focused on real-time trade reporting. Now, prior to the MSRB, Kit got his PhD from Princeton in economics, then went to work for the New York Fed, Board of Governors of the Federal Reserve.
Not that riffraff organization.
And we had a wonderful discussion at lunch. We could bring him back sometime to talk about, he was there at the initiation of New York City's problems and trying to help the Board of Governors understand what was going on. And he correctly foresaw that Puerto Rico would be a problem. And then we'll turn to the current executive director, Lynette Kelly. She joined the MSRB as executive director in 2007. She oversaw the expansion of MSRB as a result of Dodd-Frank, where we now regulate municipal advisors and protect issuers, and has a role with public pension systems. The primary, one of the major developments on her watch has been the development of EMA and the trade reporting that we all look to now for really doing municipal securities work. She's received the Municipal Forum of New York's Public Service Award, She's received a major award from the National Federation of Municipal Analysts. Prior to joining the MSRB, she was the general counsel at the Securities Industry and Financial Markets Association, SIFMA. She served as general counsel for the Municipal Assistance Corporation of the City of New York. So she too has had a role in the New York City recovery. She's a University of Nebraska graduate, Tulane University Law School. So her big claim to fame right now is she had to deal with me for 3 years on the board, and I finished that as of midnight last night. So she can tell you all about me without any consequences. Then the third speaker is Robert Doty. Robert is president of a private firm that he does municipal bond consulting work out of Annapolis. He received his law degree from Harvard Law School. He's a member of many state bar associations. He has over 45 years of experience in the municipal market as a bond counsel, underwriters counsel, investment banker, municipal advisor, author of the GFOA disclosure guidelines. That's where I first met him. And as a prolific author, as a law professor, and as an independent scholar in this area. His most recent book is the Bloomberg Visual Guide to Municipal Bonds.
You can find that on Amazon.
Good. And he and I spent some time in China together, and we had a lot of fun over there talking to the Chinese officials about the municipal market. And then we're honored to have Rick Fleming to my left. He was appointed in February 2014 to be the first director of the Office of the Investor Advocate at the U.S. Securities and Exchange Commission. And he's building this office to look at all the issues in front of the SEC, the proposed rules and regulations, problems in the markets, helping retail investors, dealing with self-regulatory organizations like MSRB. And so he's bringing a new perspective, a new emphasis at the SEC on investors. Prior to joining the commission, he served as general counsel for the Kansas Securities Commissioner. So we have a Kansas connection, although we did not meet while we were in Kansas. He's also served as a general counsel, deputy general counsel for the National Association of State Securities Officials. He graduated from Washburn University, and his law degree is from Wake Forest University. So we have a very distinguished panel of attorneys from different vantage points on the municipal market. So now I'd like to turn to Kit to start off by talking about his perspectives on the market. Whatever you'd like.
Okay. I'll stay down here, that way you won't really know how short I am, and that's just as well. For the record, I am not an attorney.
Oh,
you know, only the attorneys keep bringing that up, that I'm not. I had the joy of practicing law, but not having to get the degree. My lawyers always wanted to practice economics without a degree as well. Anyway, let me go back to when I started the MSRB, because I think it gives you a perspective on sort of some of the structural issues that are associated with this market and how it developed over time. And we still see vestiges of it in various places, and it still presents problems for the SEC and for the MSRB as we go forward. In 1978, there were about 1 million different tradable securities outstanding, and the total value was up around $1 trillion. No one has precise numbers, but that's good enough for government work. $1 trillion and 1 million different tradable securities. But the dealers did not always know what they were trading. And customers were even more clueless about what was being traded. So when you don't know what you're trading and you don't know what you're buying, accurate pricing or having a fair and efficient market is pretty much impossible. And as life comes around and goes around, right now you're talking about riskless principal markup disclosure and marking up and marking down, and that proposal was put on the table literally about the time that I joined the MSRB in 1978.
That's reassuring.
Well, there was fundamental problems. We could go into the proposal if we really wanted to, but that's not really an issue. What's really an issue in 1978 is that you were in effect going into a grocery store and seeing shelves upon shelves of various items. But they were all in brown paper bags, and you were lucky if you could tell it was the meat section versus the vegetable section versus the canned goods section. And even if you got to the right section, you weren't sure what was in there. What dominated the municipal market in 1978 were what economists would call informational monopolies. You would have collections of dealers in various cities throughout the country who knew the local market very, very well, or pretty well, actually, I think is the better word. They knew the deals that had been sold there, they had access to some of the information, and they traded some of the stuff. If you lived in Atlanta, you dealt with the Georgia bond issues, maybe some Alabama, maybe some Northern Florida stuff. You probably didn't do North Carolina or South Carolina stuff because they had their own communities trading the bonds as well. Some of the stuff was traded nationally. It really was not a national market at that time. In other words, the securities, to a large degree, stayed in a regional area. But the information was dominated by the dealers in that area. In 1979, we put through a requirement that CUSIP numbers be put on every transaction. And for those of you, and I'm looking out there, and there's only a few of us with gray hair or less hair, and don't understand that maybe, just maybe, none of the securities that traded had an identifier that allowed this industry to be computerized. CUSIP number is basically a 9-digit number that allows individual securities to be computerized. You put that number on it, that's what that is. You know that it's a 1, 2, 3, 4, 5, 6, 7, 8, 9, and that's associated with that particular tradable security. It's the foundation of computerization of the market. And I was very fortunate to have on the time a board member who firmly believed even in 1978, 1979, that this market would not grow unless it could be computerized. That led to the automated clearance and settlement of transactions. Prior to 1984, transactions were settled by sending documents back and forth across the country with bond opinions, documents attached, payments would go back and forth that way. None of it was computerized. And it was typified by what I saw at the then Solomon Brothers. The head of back office at that point took me up to the 28th floor of 1 State Street Plaza, where Solomon Brothers was housed at the time. And he said, look at all these people. You saw mounds of documents on their desks. Literally this high, maybe 4 or 5 stacks. And he said, see those 4 people over in the corner? They clear and settle. They settle all of our transactions for all of our stocks and bonds, corporate stocks and bonds. The rest of the floor is munis, because it was not computerized and there was no way to keep track of sort of who was getting what. So we pushed through a requirement that dealers had to settle stuff electronically, and it went a long way. Instantly, the industry, pretty quick, went from 1984, 1986, 87. I would say it went almost all book entry. Used to be, issuers would have to go to New York and sign bonds, actually physically sign bonds and issue physical securities. That all went by the board, and the industry took a giant step forward in computerization.
When was the South Carolina decision?
1987, 88, about.
Right about that time, because until then, bonds could be paper bonds.
Oh, they could be paper bonds even today, except the fact that they would not be eligible for clearance and settlement. In other words, what happened was the dealer community said, we're not going to touch these things for underwriting purposes unless they can be settled electronically, because the costs were so great to do it. Those costs in the end, by the way, are borne not by the dealer, they're borne by the issuer and the investor. Those costs get passed on. So in that sense, going to a conversation we had at lunch, part of the economic rent got shrunk out of the market, but it was basically in the back offices of the firms. So here we go to 1987, and I'll let Bob talk about the South Carolina decision, but I'm not going to talk. That's not, what was really evident in 1987 is that we ran an arbitration program, and we were monitoring what was happening with automated clearance and settlement. And what was very, very evident, I mean, our caseload expanded tenfold within a year. And that is because of a shift in interest rates had triggered a lot of call features in bonds and changed them. And the board had extensive discussions in 1987 and finally wrote the SEC a letter and said, look, we went out with a proposal to the industry first, and that was in 86. And the proposal to the industry said, we want you to put on the confirmation to customers the next available call of the bonds. For those of you who are not familiar with call features, it allows the issuer to pull the bonds back and pay off the investor. So if he had an 8% coupon and the issuer wanted to issue new bonds at 6, they could pull the bonds back, or if they wanted to change some of the indenture provisions, locking them into a particular structure, they could do that as well. But the call features were basically an issuer option, if you will, to change the characteristics of the bond. And customers were not aware of these call features. So we proposed in 86 to put that on confirmation. And it is very sad to say that in 1986 we received about 24 comment letters. Half of them, a dozen of them, came from the largest dealers in the industry. And they said, we cannot do this. It is physically impossible for us to do this because we don't know the call features. And you went, I mean, my reaction was not printable at the time, it's not printable today, because you cannot price the securities accurately if you do not know what the call features are. So even though we, 8 years earlier put QSIP numbers on and started this computerization process, we had large dealers in the country saying, I don't know what the call features are. And you go, oh my God. So the discussion at the board at that time was, if this gets out, we're all screwed. The board will go out of existence, the industry will go out of existence, or whatever. So the board proposed that at the time we're sitting there talking about, where do you get the call features? The call features were in the official statements. And by then, most issuers were producing official statements. They described the deal. They described the call features, they described the revenue structures, and the like. And so the board in 1987 said, look, SEC, if you require issuers to prepare an OS, we will require that the underwriter provide us with a copy of it. I cannot tell you that it was the most contentious, over even political contributions, the most contentious issue. Dealers around the country, I think, and bond lawyers recognized that this would destroy a number of their informational monopolies because the information in the official statement now would be widely available to anyone who wanted it. And it was typified by a bond attorney as we were going through and discussing this with the industry about what we proposed to do. I was at a meeting, a bond attorney came up to me at the break and he said, "Kid, do you know, you're going to fundamentally change the industry." I said, "Wait a minute, these are public documents, it's not going to be that big a deal. All we're doing is putting them in a place, somebody's got to go read them, figure them out. I'm not, changing the industry." I said, "Oh yeah, you are. Because we could change the call features after the bonds were issued and nobody would know. We just did it. We were the bond attorney. We just, changed the call feature." Anyway. So that was another one of those unprintable reactions that I had. That was 1989. That was 10 years later. And so we finally started collecting OSs, and I'll let Lynette sort of take you through sort of where it's evolved to. We started collecting the OSs, and it was kind of funny because the SEC said, "Well, you can collect them, but you can't scan them. You can't make them electronic. You have to file for that." So we went and filed for that one too. And that was another year of yelling and screaming at us. So it was a tough 1989 to 1992 was not easy. But it was also, I think, best described at the time by Michael Bloomberg, who at that time was still head of Bloomberg before he became mayor of New York City. And we had several of the information providers in the industry violently opposed to what we were doing. But Bloomberg hadn't written anything. So I went and visited with Mike Bloomberg and I said, "Look, we'd like it if you write a positive comment letter. You're trying to establish a database just like Kenny, just like a couple of other groups, with a complete listing of all of the features of the bonds. And this will make your job easier." He paused. He said, "I'll tell you what, I'll make it easy. I won't write a letter against you, and I won't write a letter for you. And here's why. Yes, you would make my job a lot easier by collecting the official statements, because then I won't have a staff of 30 people in Princeton, calling up bond attorneys and underwriters and trying to collect these official statements from around the country. I'll be able to go to you. But it will allow other firms in future years to get into my business too." So in effect, what was happening is Mike understood the informational monopolies that existed within the industry, and while he was willing to eat Kenny's lunch and a couple of other people's lunch, he didn't want other people eating his. So it was a real economic kind of discussion that we had. But once you have accurate identification of the securities and the features of the securities, you can then talk about pricing. And here we were 14 years out from riskless principal markup disclosure. And I was going, aha! But the SEC was breathing down our neck and suggesting something needed to be done with pricing. So we then started the process of setting up a transaction reporting system. It went through 3 or 4 iterations where we went from next day reporting to 15-minute reporting to whatever it is now, in order to make readily available to all participants in the market what the price of the securities were. I would also say that because call features and that information is now widely available, the pricing that is out there will be somewhat better. During my time, we also were involved in having to deal with the integrity issues of the market. The market was fundamentally restructured by the 1986 Tax Act. More and more issues became negotiated, and the result was that political contributions and the role of consultants grew mightily and was basically a corrupting influence on the market. so we passed G37, which banned dealers from giving political contributions. Here's another one good one. So after the rule was in effect, 2 dealers were observed on either side of the state treasurer walking out of a meeting where I had just spoken. The state treasurer turned to these 2 guys, both from a very large firm, and said, "I don't give a goddamn what the MSRB says. You better figure out how to get me the money." And so we ended up with consultants, and we ended up with all kinds of issues like that. We finally passed the ban on consultants, I think, in 2005, 2006 timeframe. I'd like to end by saying I'm delighted to be here because what you are talking about a lot as a group is issuer education. And one of the things that makes markets efficient and fair is when the participants, all the participants have generally the same level of knowledge. And one of the things that's been very troublesome to me throughout my tenure in the MSRB was to see what I consider to be a huge gap in financial sophistication between the issuer community and the dealer community, or the dealer community and the investor community. So I'm very much in favor of educational efforts. At one point, I know the program listed me as being associated with Fixed Income Academy. I don't get any money from them. I did some work in helping them get set up, and I've encouraged all of their efforts. And if you're not familiar with it, they do have a website, Fixed Income Academy, which is trying to provide some sort of educational efforts directly to online courses to issuer officials and the like. And to drive home the importance of education, I will finish with one other little story. It's 2003. Derivative contracts were becoming a big deal in the industry. New issue bond deals were not being done without an associated derivative being issued at the same time. And it was pretty clear all kinds of stuff that we had banned, political contributions, all kinds of other activities were being carried out over in the derivatives market, which we did not regulate and were actually prohibited by Congress from doing. So I had been invited to speak to the head of fixed income for a very large mutual fund complex. And I went to that meeting, and the head of that firm, the head of fixed income, and several other high-ranking executives were there. And I started to talk about the role of derivatives in munis and how it was becoming an increasing problem. And I made the comment that I didn't think many issuers understood that derivatives were not a security, and so their protections that were available to issuers through the issuance of securities into the market were not there at all for derivatives because they were contracts. The head of fixed income security started yelling. He said, "They are securities. I trade them every day. They are securities. They are not contracts. They are subject to federal securities law." I said, "No, they're not." This discussion went on for a couple of minutes, and finally the person that invited me timidly raised their hand and said, "Sir, they are contracts. They are not securities." And so this told me, you better know what you're talking about, you better know what you're doing when you're in this business, because otherwise somebody will take you. And it was sad, but that's why I am a real proponent of getting education, and I will shut up. Thank you.
Good message. Lynette, bring us latest on the market.
Great. I will. Thank you so much. And I'm really just pleased to be invited today. Kit, from his very short description, really left the MSRB in great shape when I came in 2007. The work that was done during Kit's tenure was fundamental, was foundational, was really ahead of its time. When we talk about the municipal market, a lot of people think it's sort of sleepy and opaque, but frankly, there are so many initiatives and developments in the muni market that have been adopted by other capital markets. So it really is a market characterized by a lot of innovation, a lot of industry effort, and really leading the way in many respects. Always happy to be on a panel with Robert Doty, who is really, I guess you could describe him as a watchdog, but he is a scholar, a gentleman, a volunteer on our professional qualification program, and it's really been just a guiding force in our market, and has worn a lot of different hats over the many years. Rick took something out of nothing. I don't know if you know this, but at least at MSRB, we call you the 6th SEC commissioner. So, you know, when you speak, people listen and pay attention, and you've been a really incredible advocate.
And she didn't misspeak, it's to call you the sick SEC.
And finally, but Bart is much too modest, but Bart served on our board for 3 years and was a passionate spokesperson representing the public, advocating for more academic research, advocating for transparency. I understand even till 11:59 yesterday when you left the board, you were still going strong and making your opinions heard. So I hope you come back one day. But it's been a pleasure to serve. Clearly you've heard a little bit about the market. You probably know a significant amount. So let me just take it from where Kit left off in 2007 up to where we are now. Kit was, again, pretty modest. He didn't talk about our Rule G17, which is fair dealing. One sentence, you must deal fairly. And so we've extended that rule applies to the brokers, dealers, banks, as well as municipal advisors. That is a principles-based rule. It is short and sweet, but it is very broad and very comprehensive. And it captures, you know, any number of different kinds of nefarious and other kinds of activities, and there have been a significant number of enforcement cases brought under that rule. You heard about the pay-to-play rule, which that many years ago was really the only rule of its kind to disconnect the making of a political contribution and the award of business. But it is a rule that's been copied by the SEC for investment advisors. It's now being copied by FINRA. It's copied by any number of states. So it was really the groundbreaking rule on pay-to-play activity. And then the real-time trade reporting system, the first ever in the fixed income markets. And so I really inherited a very strong organization which had some very significant initiatives to its credit. So I think I was there at the time when rulemaking was something that we did very well. But we were also really at a point where we had a very broad mandate, and we know we could write rules, but we really focused on what are the other tools at our disposal to fulfill our mission, to promote a fair and efficient market and to protect investors. And technology was at a point where we felt like transparency and democratizing access to information was really something that was equally important. And so we put a significant amount of effort into creating our MS system. It is a free website to make information available over those. It's a little bit more than 1 million individual securities now. It's about 1.3 million individual municipal securities. So it's the primary market offering document for free on EMMA. Secondary ongoing disclosures made by the issuer through the life of the bonds, easily accessible on EMMA. Material event notices that the issuer posts if there are defaults or any other types of material events that an investor needs to know about. Trade data. We implemented a new feature where we provide interest rate resets for the short-term instruments in our market. Market data, functionality, utility to compare bonds. We've got a price discovery tool because municipal bonds don't trade frequently, but you look at as similar securities and the trading activity of those similar securities. So we put those features up on Emma really to, again, empower the retail investor so that they can question the broker, they can question their investment advisor. I see you bought the bonds here, why are you selling them or offering them to me 2 points higher 5 minutes later? So really amazing, an amazing, really a strong turning point in the market. And we were really only able to do that because technology was at a point where we could harness the technology. This organization stepped up to pay for that because this is a free website. It's easily about $13 million a year to operate. When we talk about technology in the fixed income markets, they have to be up 24/7. There's disaster recovery tests, software development ongoing, and so we continue to add to the MS system again to really harness the full power of that utility. So we've got rulemaking, we've got transparency. Equally important is a very strong education and outreach program. So as Kit alluded to, we spend a lot of time trying to reach people, and we use surrogates to get to the retail investors and the smaller issuers. We have a whole host of educational materials that we make available free. And it's not just, here's a paper, here's a checklist, here's a piece of paper. There are videos, podcasts, webinars, any number of different ways that we can deliver educational content to these folks. We also, I'm a firm believer that a very well publicized enforcement action can change behavior very quickly. So we spend a lot of time behind the scenes supporting the enforcement of rules and other rules that would favorably impact the market. So I know when the SEC brought a charge of enforcement case against the state of New Jersey on their pension disclosure, 49 other state treasurers were on the phone 5 minutes later talking to their lawyers to make sure that their disclosures were robust and adequate. So there are many different tools in the toolbox, and we try to be nimble and try to choose different options to get the word across, and again, just to fulfill, how do you promote a fair and efficient market? We, in 2010, with the passage of Dodd-Frank, our original mandate was expanded to also include the protection of issuers, as well as the regulation of municipal advisors. So we've been spending the last 5 years constructing a regulatory framework for the municipal advisor community. This is a group of professionals. I'm sure many are perfectly qualified and want to do the right thing by their client, but it was a group that were totally unregulated. No professional qualifications, no ongoing continuing education, no registration, no rules, no nothing. The people that give a manicure have to have a license, they have to take classes, so they were more highly regulated than municipal advisors. Sorry, you were one of them, but you were one of the good guys, right? But they were more highly regulated than a municipal advisor advising on a $500 million bond issue. So Congress in 2010 saw fit to bring those professionals under a regulatory framework. We constructed a professional qualification exam for this community, which will be given starting in January of next year. And we're working on some core, very fundamental rules. The first is to articulate what a federal fiduciary duty is to their client, what it means, how to disclose conflicts of interest, what conflicts are so unmanageable that they're going to be prohibited. The second is to extend the pay-to-play rule to municipal advisors, deal with the issue of gift giving and excessive gift giving. We really want to address conflicts of interest head on. And then finally, supervision. How do you construct an environment in which municipal advisors operate that is cognizant of the rules, that there's training, that there's a compliance structure and an ethical tone at the top. So that's been a huge initiative for the MSRB in addition to continuing to build the MS system. You may also know about the SEC's interest in our market, and in 2012 the SEC issued a report on the municipal securities market with a significant number of recommendations about the market and what we should be working on. Many of those initiatives had already been identified by the MSRB board in earlier documents and priorities, strategic plans and the like, but that's really been, on the dealer side of the equation, that's really been a very significant part of our efforts over the past 3 years. That generally falls into a couple different categories: improving disclosure practices so that issuers understand their obligations, and they use Emma as a conduit to get that disclosure into the hands of retail investors at the same time that it gets into the hands of the professional investors. We want to enhance market transparency, so we've enhanced post-trade data elements that are made available, and we're also exploring whether or not there's pre-trade information that might be helpful to make available to retail investors, and looking at the structure of the market, specifically with an eye towards empowering and enabling and protecting the retail investor. So some of the examples are implementing a best execution rule in the municipal market. It would require a dealer to look at various execution venues and transact in that venue that at the most favorable price to the retail customer. We are also very excited about an initiative that we've been working on for a while, and we just put out a request for comment late last week, and that is to finally possibly bring to conclusion something that Kit talked about and that's been talked about in the fixed income markets for a long time, which is markup disclosure. And it is as simple as knowing the compensation that you are paying to your broker for executing a transaction. And investors, I believe, are really smart, and they may absolutely be fine to transact with a full-service retail broker providing a vast array of services, and they know that they might be paying a little bit more than if they did an online transaction in a more self-directed way. But no one really was ever able to ascertain how much is my broker making. And in this era of technology and the real estate apps where you know what the house next door sold for and you can use comparisons, or buying a car, there is absolutely no reason why we can't bring that same level of transparency to transactions in municipal securities. So we are working very, very hard on this. My personal view is that the industry, whether they're going to embrace it, I don't know, but I certainly view that they know that the time is here. I can't imagine them writing a comment letter and saying, oh, the investor really doesn't care about that, or they don't really know that, or it's not important for these reasons. So I think the real challenge will be, how do you construct a process that is as efficient as possible, because it'll require a lot of IT systems changes at the dealer level, but still get to the point as quickly as possible where the retail investor has that knowledge. So with that, you get a little bit of a sense of some of the things we're working on right now, and I think Kit can probably share this view. You know, the work never stops, because just when you have done something and you pat yourself on the back, there's more challenges, more issues, more problems, and more exciting things to work on.
Thank you. Robert?
Well, I think that Kit and Lynette have done a fantastic job. It's interesting to look back the time before the board existed. I'll just tell this story. I had been a corporate securities lawyer for several years, and was a law school professor for a little while. And in the early 1970s, I was was employed by a law firm to consult with them and do research and write papers on the question of whether the securities laws apply to municipal bonds. It was that simple. And the only law the only laws that applied at a national level were Rule 10b-5, the SEC's anti-fraud rule, and to some extent Section 17A of the 1933 Act. But that did not literally apply to municipal governments to prohibit fraud by them. And that was important because in enforcement actions, the Commission could use 17A for a negligence standard as opposed to an intentional standard of fraud. Well, in that time frame, the SEC brought a couple of enforcement actions against dealers. One against a dealer who underwrote land-based securities in California and did not check into the financial and operational capabilities of the developer of these bonds. These bonds were payable for taxes on land that had not yet been developed, and the taxes wouldn't be forthcoming unless the developer were successful. And another action, it was a dealer hit on the notion of selling bonds to returning Vietnam veterans. And that was important because those are people who had not spent their money for quite a few years.
POWs, actually.
POWs, that's right, R.J. Allen and Associates. And the bonds they sold to the Vietnam veterans were industrial development bonds, depended upon the success of private projects, private companies, in which R.J. Allen owned an interest. And of course there were phenomenal failures. The POWs lost a lot of money, and that was before, even before the New York City crisis. And then we had the New York City crisis. The New York City crisis was so serious that the market literally closed for a period of time. It was very difficult. Very few bonds, if any, were issued. I don't know that there was much trading going on. I don't think there was, according to my recollection. And everybody was very confused about what to do. The Government Finance Officers Association put together some disclosure guidance. Legislation was passed which amended Section 17A of the 1933 Act to add issuers. It also established the board for dealer self-regulation. Out of 15 members, 2/3 were dealers. So I think it's fair to say that was dealer self-regulation. There was one critical provision, the Tower Amendment, although I think for the most part, people give the Tower Amendment more credence than it deserves, because at least as far as the SEC is concerned, I don't think the Tower Amendment means anything. All it says is that the SEC can't require bonds to be registered before they're issued. The Commission doesn't have that authority anyway. The Tower Amendment does restrict the board, however, and it's kind of interesting how this has worked out. The Tower Amendment essentially says the board can't indirectly require issuers to make disclosure by putting a disclosure burden on dealers, in effect. But the SEC's done that. It's very interesting how that has worked out. Well, from the early days, and I was with the Government Finance Officers Association here in Washington at that time, 3 rules that we were very interested in. Well, we weren't actually all that interested in Rule G17. G17, though, is a very, very powerful rule. I describe it as, thou shalt not do anything naughty. And that's pretty much it. Thou shalt not do anything naughty. But we were interested in Rule G32, which required dealers to deliver official statements to customers in offerings. And I took the position that if the issuers are going to put this together, the dealers ought to pass it on to the customers. And then there was another rule, Rule G23. And this is one of the most serious mistakes of my life, but I have so many of them. So when I say it's one of the most serious mistakes, it's in a long line. But essentially, the rule said, as initially drafted, that a dealer who served as financial advisor could not underwrite the bonds for the same bond issue. And I got calls from a lot of issuers in Texas, and I got calls from also issuers in ironically, Connecticut. And they said, no, that's going to take away our choice. And so I advocated that issuers should have the choice on this conflict. I regretted it very soon in the 1980s when I became an investment banker. After I left GFOA, I was a bond counsel. I became an investment banker. One of the first things I was told was get hired as a financial advisor and then switch. I immediately saw the big mistake I had made. And from that time onward, I began to argue and argued with Kit. It wasn't his choice. But people, the dealers did not want to make that change. They wanted to be able to go in as financial advisor, and in fact, in Texas and in parts of the Midwest, they marketed themselves as financial advisors. And as we moved on through the 1980s, kids talked about a lot of things that happened then. The paper bonds were being used allegedly to launder money. They were worth cash. They had long sheets of coupons attached to them, and people would cut those. I remember seeing people cut those with scissors. They'd send them through the banking system just like checks. But they were like cash. And the federal government put a stop to that through the tax code. There wasn't a lot of action really in the 1980s. I did see some of the effect of board rules, but not much. We didn't really pay a lot of attention to the board rules in the 80s.
You were an investment banker then, weren't you?
I was a bond counsel, I was an investment banker. Nobody.
Now you see what my problem was.
I didn't know any investment banker who knew anything about any of the rules, except they knew they could resign as financial advisor and become an underwriter. One of the evils of that is they could structure the entire transaction, and as financial advisor, recommend this transaction to the issuer, and then switch and underwrite it. But all the work had been done in supposedly a fiduciary capacity. Then we get to the early 90s, and again, another big mistake. Kit alluded to the informational and the creation of the NERMSers. In effect, he talked to Bloomberg and was Kenny and so on, and I advocated against the board on that. Another big mistake. But you look back on this, and all I can do is plead humanity and closed-mindedness, I suppose I have to admit that. But as we moved through the 90s, people became gradually more aware of responsibilities. The SEC imposed a continuing disclosure regime through its Rule 15C212. It basically said underwriters cannot underwrite bonds unless issuers agree to make continuing disclosure. And those continuing disclosures were to be filed with the NERMSers, which really the NERMSers lost them, the issuers didn't file them. It was a zoo. It was just a zoo. As we get into the 2000s, we've now had quite a few SEC enforcement actions. I think people realized the NERMSers weren't working. We headed in the direction of EMA, which became the only filing location in 2009. And it's a terrific resource. All sorts of information, not only for investors but also for issuers. And there was much improvement, but in the 2000s also, Kit talked about the derivatives. Underwriters were recommending derivatives to issuers. They were going out into Pennsylvania and recommending derivative transactions to little school boards. And they were selling them to little towns in Tennessee. Not only did the issuers not understand these, the underwriters didn't understand them. They didn't know what they were marketing. All they knew was they would get paid a lot if they got the deal done.
And you want to know, Mr. Harvard lawyer, who paid one of the biggest settlements on a derivative?
Well,
The Harvard Endowment.
could that be the Harvard Endowment?
Paid $500 million to get out of its derivative.
And if it had just sat there on those derivatives, it wouldn't have lost that much money by any means. But I mean, there were lots of transactions that were being recommended by underwriters. But when people complained, the underwriter's response was, "We're dealing at arm's length. We don't have any responsibility to the issuer. It's not. I mean, we can't lie, but we told them the truth, or we didn't tell them anything at all, and that's not fraud. It's not fraud to be quiet." After the financial crisis, Dodd-Frank was enacted, and the market really changed, I think, fundamentally. We now have a board with responsibilities to issuers as well as investors. That's important for investors because the issuers don't know what they're doing. It's very important. Municipal advisors are the scheme, if you will, wrong, it's not a good word, the plan, is for municipal advisors to advise issuers. That happens most of the time now, not all the time. Underwriters can't recommend to issuers that they not employ advisors, and the advisors are now going to be regulated. Although it's taking a long time, that's not Lynette's fault. It's a heavily lobbied issue with many, many interest groups, but it is gradually taking shape. And I think as we move forward, looking forward into the future, there is some reason to believe that the municipal market can improve. I don't think we can ever educate issuers. I just think that's a hopeless task, except for some of the very large issuers who wish to pay attention. But frankly, and the large issuers issue most of the bonds, let's say 50 to 60%. I don't know the exact percentage, but that could probably give you a better number. But there are tens of thousands of small issuers, and they're in places like I use Sheridan, Wyoming. I pick on Sheridan, Wyoming, little town. I've been there. It's just outside the Crow Reservation, and I don't know how often they issue bonds, but it certainly isn't every year. It probably isn't more than every 5 or 10 years. And you know what happens is, first of all, the people who are running Sheridan, Wyoming know nothing about municipal finance. All they care about is filling potholes and plowing snow. They don't know anything about the bonds. And when they sign documents to bond lawyers and underwriters and financial advisors or whoever, they're just shoving documents under the nose, sign here, sign here, sign here. They don't even know what a continuing disclosure agreement is because nobody ever tells them. And so when it's all done, they have a stack of paper like this, and everybody is shocked after the fact when somebody says to the mayor of Sheridan, Wyoming, "But didn't you know what the continuing disclosure agreement says?" He said, "I don't even know what a continuing disclosure agreement is. What you signed this, well, that's my signature, but I still don't know what this is." I can't tell you how many times I've seen that scenario play out. And here's the problem. Even if you teach the mayor of Sheridan, Wyoming, what a continuing disclosure agreement is, what a 10b-5 certificate is, what an official statement is. How did you approve this official statement? I don't know. Well, it's right here in your bond resolution. It says, "Will you approve the official statement?" Well, I guess that's right. It does say that. Did you read it? No. Did you ever see it? I don't know. Well, okay, so we take a couple of years and we educate the mayor of Sheridan, Wyoming. And 6 months later, the mayor's voted out of office. And we have a new mayor. And the finance director has moved on to Gillette, Wyoming. And and they just hire somebody out of school to handle their financial matters. And you got to start all over again. The only way that these issuers can understand even the most rudimentary elements of a transaction is to have somebody who's responsible to explain it to them. And you say, well, how about the bond lawyer? Well, I'm going to tell you that I've been a bond lawyer. I'm going to tell you that the bond lawyers don't take the municipal officials aside. And remember, you're not just talking about the finance officer, you're probably talking about the local lawyer and the mayor and the city council. And explain it to them that bond lawyers haven't historically done that. Now, there are bond lawyers who will do some things like that. Somebody needs that responsibility. And to a certain extent, the municipal advisor regulation is going to provide for some of this. Now, there are certain themes in municipal finance also, and I'm not sure whether these will ever be cured or fixed or not. But I always keep hoping. Because I do litigation consulting and a lot of expert witness work, I see a lot of this stuff. A constant theme, feasibility studies. The feasibility expert makes assumptions, and nobody asks them what the assumptions are. Now, the good experts will put the assumptions in a study. The really good experts, there are a lot of them, will say these assumptions are reasonable. But nobody reviews those assumptions. I'm thinking of an entire transaction that it was unsaleable until collateral was added. And there was an asset valuation for that collateral. And that asset valuation exceeded the amount of the bonds. And that expert said, you have to assume that this is going to be an ongoing company. You have to assume that everything I've been told is correct. I'm just doing this on the basis of what people told me. I didn't do any checking. And nobody read that study. Nobody knew. They were selling the bonds on the basis of a study where everything was assumed to be true, and nobody had done any due diligence, not even the supposed expert. So there's a lot to be done. A feasibility consultant, in many cases, will be deemed to be a municipal advisor, and hopefully some of that can be fixed, as well as conflicts of interest, another constant thing. So I'm going to stop, because I have to.
Well, with that, we turn to the investor side. The person who's responsible now to the SEC and to the country for protecting investors. While the SROs and the SEC commissioners have that as their duty, it's in your title.
Yeah, it is. Well, first of all, I have to give the standard SEC disclaimer that my views that I express are my own and don't represent the commissioners or the commission or anybody else on the commission staff, which ought to be patently obvious because my job is to express independent thought. That really is my job, to be a voice for investors. I'm asked a lot of times, why does the SEC need an investor advocate? Don't they have 4,000 investor advocates on the payroll? And there's a lot of truth to that. Yes, they do. And I didn't come to my job viewing the SEC staff as the enemy or anything like that. I think they do a good job working on behalf of the American public. But the basic idea in the creation of my office is actually a creation of the Dodd-Frank Act. So it came about after the financial crisis. And I think the feeling was that the industry was starting to have too much influence over the policy-making process. And so I'm supposed to try to provide a counterbalance to that, I guess, by speaking on behalf of investors as decisions are being made that have an impact on them. So one of the things, kind of the most obvious thing that I do is look at the rulemakings as they flow through the commission and examine the impact of those rules on investors. And I can make recommendations for changes as the rules flow through. I can actually make recommendations about existing rules that I think ought to be changed. Just about anything that I want to pipe in about that's going on at the SEC. But beyond that, even though I'm housed at the SEC and I'm an SEC employee, I'm also supposed to review the rulemakings as they flow through the self-regulatory organizations, which includes FINRA, which includes the MSRB, which includes the stock exchanges. And so we're in the process of gearing up and trying to keep an eye on those rulemakings as well. And so from time to time I chime in on rulemakings at the MSRB and FINRA and the exchanges. So, given that, well, the other thing that I do is I report to Congress twice a year, and I can make recommendations for legislation that might be beneficial for investors. And in my reporting to Congress, that's one of the things that makes my role really unique, because I'm supposed to file my reports with Congress without any prior review by anyone at the SEC, including any of the commissioners. So that's what really gives me an independent voice for investors. That's a really kind of unique thing. If you've ever known anybody that works at the SEC, nothing comes out of there that isn't sort of blessed by the chain of command. And so that's a really unique kind of part of my role is to be an independent watchdog on behalf of investors. But because of sort of this scope of potential things that I can be looking at, basically any kind of policy making that's going on, legislation, rulemaking at the commission, something at the SROs, anything that's going on that has an impact on investors, I could potentially be making noise about. That's a huge, huge broad mandate, and my office has existed now for a year and a half. I only have a handful of staff, so limited resources, just like everybody else. So I've had to sort of pick. I thought it would be more useful, instead of me kind of following the daily headline and screaming about every little thing, to focus in on a manageable number of issues that me and my staff can really dig into and try to have more of a constructive role in the process on that limited set of issues. So in my first report to Congress, I had identified 6 things that we were going to look at in our first year. Now that sounds like a short list, but things on it include equity market structure, disclosure reforms, some things that have pretty big buckets. But in that list, I included looking at things in the municipal securities markets and potential reforms there as well. And the reason that I picked that as one of the things that we wanted to focus on is that some of the research suggests that there's a pretty high concentration of retail investors in the municipal securities markets. In fact, if you look back at the history around the creation of the MSRB, prior to the 1970s, it was pretty much an institutional market, dealer to dealer and institutional investors. And in the 70s, that started to change, where you had more retail participation in the markets. And then it was really one of the driving forces behind the creation of the Act, was to protect investors that were starting to participate in the municipal markets. And I think that's just grown over time. And so that's what drew my interest to this particular set of issues, was the fact that there's so many retail investors in that space. Anything else I should know?
Keep going.
No, I think that's good. That's good for now.
Okay. Well, that was an excellent introduction and overview of the market. I gave you some questions. Let's go through a couple of them. We want to have a few minutes for any questions from the audience. What did Congress get right or wrong in its framework for the MSRB? Short answers.
Okay, I think Bob correctly pointed out, and so is Lynette, that first of all, let's divide the time frames between 1975, when the board was first created, and 2009, because I think post Dodd-Frank you have a different set of legislation. So we can talk about what they didn't get right in the first piece, and then you can talk about what Dodd-Frank did or did not do. At least from my perspective in the first piece, I think that given the state of the market at the time that it was enacted, they did quite well, okay, in terms of what they put in there. I think the problems that have developed and the evolution of the market as it's went through the 90s and into the 2000s before the crisis said, okay, this structure really doesn't work. And it doesn't work because you cannot, in muni space, what was happening was the interaction between the dealer community and the issuer community, and by extension to the investor community, was that issuers were being pitched bond deals with an associated derivative. And it doesn't take a lot of rocket science to realize that if you regulate one part of something and you say you cannot do anything over here, you can't give political contributions, you can't do this, you can't do that, all of which are MSRB rules, and then you have an unregulated part over here and they're joined together in the transaction, guess what? The unregulated part sucks up all the problems and all the bad behavior. And so there were numerous examples of where a bond deal would be done really according to the rules, everybody was following them, so forth. Over here, political contributions, collusion, you name it, screw the issuer, screw the investor, and the like. And so the legislation didn't take into account, if you will, and I'm not sure any legislation ever can, evolutions in markets. At the time the board was created, it was a dominant new issue market where there was competitive bidding. It's now almost all negotiated. And I have problems with the fact that it's all negotiated because of what it can lead to in terms of poor behavior. So,
I would absolutely agree. I think Congress has a constant ability to get it right. So they got it kind of right in 1975. They, perhaps not very quickly, but in 2010 they needed to get it right again. I think there's a lot of oversight of the market right now. There's a lot of, Congress is very involved in the market, right, because of the retail nature of the investment, as well as, you know, it's the 2/3 of infrastructure in this country is funded through the municipal market. So it's a hugely important market. I guess my point would be the market also takes care of itself very well. And I think that that is sometimes lost. I think that government thinks that they can fix everything. Well, the structure of our government leaves a lot of individual autonomy to the states and state and local government decision-making, what to finance, how to finance it, the decision to create debt. We've got a lot of industry groups in our market that have put out best practices that have really changed behavior. We're seeing a lot of actions by state governments themselves, for example, related to the pension issue. So states are really being very proactive in many ways. We also see some states taking a much more of an oversight role for local governments within their jurisdictions. About half the states have a pretty sophisticated system of oversight. So hopefully governments, you can sort of spot some early warning signs before they local governments fall off the cliff before it's too late. And finally, even places like GASB, you know, the Government Accounting Standards Board, they've just announced an initiative to look at a going concern project. So state governments or local governments don't go out of business like a corporation, but what are some of those accounting standards that might be implemented, again, to give people some early warning signs about some fiscal distress. So I'm not sure all the answers have to come from the federal government.
Robert?
Well, I think that during Kit's tenure, the board did what it could as a dealer board, a dealer self-regulatory board under that regime. I think in the 2000s it became very obvious what the underwriters were doing vis-a-vis the issuers. And it also became very obvious that there were many advisors who were not particularly good at what they did. And there were many, many conflicts of interest in both of those roles. With the change, the board is no longer a dealer self-regulatory board. I describe it more as a market self-regulatory board because it's a majority of public members. With the regulation of the advisors, hopefully, as this takes shape and Rule G42 is finally promulgated and enforcement actions proceed, hopefully conflicts of interest are going to be suppressed. I don't know they can ever be eliminated completely. But the board used Rule G17, I think, very well to make clear that underwriters did have duties to issuers. Not only not to lie to them, but when recommending transactions, to provide information about what was being recommended. So that was a big step forward also. So there, both and Kit, during your years, not only did you adopt, did the board adopt rules or interpretations of G17 to protect investors, the dealers had to tell investors information they knew, but they also had duties to issuers. There are some early interpretations going back to the 1990s of that, and that's been brought forward and expanded. So I think we have vast improvement. I think there's still some things that can be done, but I'm very optimistic, and I'm looking forward to the future.
Great. Mr. Investor.
Well, Lynette commented about the autonomy of the state and local governments, and generally speaking, that's a good thing. And I'm an old state regulator, so I'm a states' rights guy, pretty much to the core for the most part. Also grew up in a very small town, by the way, 600 people, 15 people in my graduating class, and that was a public school. So I really understand the importance of, well, first of all, I understand the lack of sophistication, I guess, of the local rural water district, and some of these public officials that are doing their best, but maybe don't understand the nuances of the 33 Act and that type of thing. But having said that, I do think that the Tower Amendment, which is basically what preserves the autonomy of the state and local governments, I think it has sort of contributed to, I don't want to state it too strongly, but it's basically, it's obstructed some positive evolution in the industry, I'd say, and in particular, I would sort of point to the difficulty in establishing a really effective and efficient secondary trading market. I think it's really difficult to do that when you have varying accounting standards. Like not all the local governments supply GASB. They have differing ways that they approach different disclosure obligations. And basically that's, in some part anyway, a large part I think, a result of the Tower Amendment and the inability of the SEC or MSRB to really put some structure around the disclosure requirements. And I guess I'd take issue with Robert, who said that the SEC doesn't really abide by that. I've had conversations with people where they see that as a real impediment to being able to get issuers to do the type of disclosure that they'd like to do.
Well, I think my point, Rick, is that the real problem is the lack of affirmative authority. The Tower Amendment said, I mean, as far as the Commission is concerned, all it says is the Commission can't require that securities be registered before they're offered. It's a bigger impact with respect to the board. But
okay, I'm gonna pick up a piece of what Lynette said and challenge you all to think about this. Okay, so you want a market solution. The market will take care of itself to a certain degree. So here's what you do. The MSRB says, we're going to put on the confirmation a red light, yellow light, or green light. And the green light is the issuer has agreed to meet some specified standard, set it up by the National Association of Municipal Analysts. I don't care who it is, sets a standard. And the issuer said, we'll do that and we'll file regularly with the MSRB, and as long as we file regularly, we're going to get a green light on our confirm. And all you have to do is go to Emma and you see, okay, they got a green light next to their name because they're following the disclosure standard. The guys that are sort of like your town, where you grew up, who are trying maybe to do a good job, but they are unwilling to spend the money, time, or effort to meet a GASB standard of an independent audit, done, you know, whatever. A much higher standard for a much more sophisticated issue. But they're providing some disclosure. You give them a yellow light, okay? We're going to give you some disclosure, but we're not going to give it to you according to the standard. Again, if it doesn't get filed in the MSRB, okay, MSRB can change it. And then there's the guys, and there are some out in this country who say, screw you and the horse you rode in on, and we are not abiding by any standard unless it is absolutely required by an act of Congress, and they get the red light.
They get the skull and crossbones.
Exactly. And so the point being that in that instance, the market and the dealers who are selling to investors are making the decision of how you price the security. And so the issuer then gets it shoved in his face as to whether or not disclosure matters. Throughout the 80s and 90s, whenever I talked about disclosure, the issuers, GFOA included, said, if you can show me how much it costs, I'll be glad to do it. Okay, there's a proposal to show you how much it costs.
So I have to say, and I'm sorry, but I remember when there used to be contests which local governments had the best disclosure practices, and almost for like 3 years in a row, Jefferson County, Alabama, was number one.
Yes.
Seriously, the
Yes.
best,
That's right.
more information. So, because we have the MS system, so we often think, should we put a skull and crossbones if they're late filing their financials? Should we put a smiley face if they're in early? And
That
there's a
goes to
real,
what she's doing.
yeah, there could be real confusion for a retail investor that smiley face, just because they're in early, doesn't mean it's a good credit, doesn't mean there aren't problems, doesn't mean, so,
Yeah.
I hear you, but I think,
no, I agree.
but
That's very valid.
I think you are, the idea is right, because there's gotta be some incentive to force issuers, to play ball, yeah.
But I'm also very sensitive to the Sheridan, Wyoming's or whatever, and one time I saw the Red River, Wyoming District Number 2 issued $100,000 worth of bonds to buy a fire truck. They probably come to market once every 20 years if they're lucky. And so what kind of requirement do you put on them for disclosure? How do you deal with that versus in New York City or New York State or something like that?
Let me ask
Well, what
one
has
last
changed?
question.
I'm sorry, go
Let
ahead.
me ask one last question. And then,
You can try.
yeah, try. You've got some academics in the audience. What can they do to promote a fair and efficient market? What's the role of the audience to help this market?
Data.
Education. Outreach to those people who are making the decisions at the state and local level. You know, whether it's the mayor who changes office in 2 years or it's the, you know, local fire chief or whatever. Education, you cannot get away from it.
Okay.
Well, I disagree. I disagree. I don't think there is any way possible to educate these issuers. I don't think it's possible. They have to accept responsibility, whether they can do it or not. They have to be told they have responsibility, and they are being told that now. Now the $100,000 fire truck today is being handled by a direct loan from a bank. What's happening is issuers are leaving the market in droves, and they're going directly to banks. The disadvantage is those are limited maturities. You know, the 10-year horizon's about more or less, not the old 20 or 30 year. But what can be done for researchers is to attack policy issues so that policymakers can benefit. But I'll use the example. I'll use the example that I used in Boston, and that is the SEC made it very clear to issuers and underwriters that they needed to have clear disclosure in official statements when issuers did not conform to past continuing disclosure agreements, and they didn't do it. The SEC hit them about the head and shoulders with baseball bats, and people didn't listen. And now we have the MCDC program as a result to get their attention.
Lynette, and then the last word for the
So, the Brandeis Conference is huge in our market. We have seen the number of researchers interested in this market, the academic interest just skyrocket. I would say so. More research, certainly. I would say that though it is incumbent upon you to understand the data. Municipal market data is not clean, it's not easy. It requires a significant amount of cleanup and understanding. And so really, ask the MSRB, ask us to help you with the data, ask market practitioners. So that is really important, because there are studies that sort of have conclusions, but some of the data appears to be flawed. At least that's some of the issues that we have. But we have an obligation too, because all the data for the market comes into the MSRB. So our obligation to you is make that data available. So we've just signed an agreement with Wharton, the WORDS program, WRDS, to make the data available, and so that will be implemented, over the next few months. So we feel very good about that. We've also put out a request for comment on creating a specific data product for academics, which would include the dealer identifiers, so you can actually track trades through the chain. That's in a comment process right now. It would be on a delayed basis. Dealers are on one side, academics are another. MSRB proposal was kind of in the middle, which maybe if everybody's mad at you, we kind of got it right, but that'll be a decision that the board will take up soon. So, and then keep the lines of communication open. I mean, this Brandeis Conference it's a command performance, frankly, for anyone in the muni market. All professionals in the market really want to know what you're thinking and finding. So, and trust me, the SEC pays attention to it, so that means everybody else does too.
Okay, Rick.
So a few things. First of all, I should mention I just hired an economist for my little small office to do investor testing, to evaluate the economic analysis, to make sure that the benefits to investors are being appropriately considered, not just the cost of the industry. And I guess that would be my first thing that I would encourage is, I'm a real believer actually in the value of research and data-driven policy making, but that research can't just come from the industry whose ox is being gored. We need some independent research, objective research. That includes the benefits to investors, not just the costs, and that's a real trick, I know, because it's much easier to quantify the cost most of the time than it is to quantify the benefits. So I would encourage you, if you can think of some good study that you can do that would actually look at the investor side, that would be of great value to the SEC, to the MSRB, to other policymakers. I would encourage you to mine the disclosure data that is available. I'm a big believer in open data. I encourage the SEC to do more in terms of providing structured data to the analyst community, but also academics. I don't really expect a mom and pop investor to spend hours and hours digging through a 10K and comparing that to other 10Ks in the industry. But if we can put that information out in a structured format so that people can slice and dice that information, and on behalf of investors, people like analysts on the buy side especially, but also academics, I think that serves a very useful purpose for you to perhaps shine a light on the bad things that you find. I think that can be very useful. So I'd encourage you to perhaps shame the people that engage in the more abusive practices by finding, using the data and slicing it, dicing it to do interesting things with it. And I guess the last thing I would do, in particular in the municipal markets, I think there's a real need for a better, more efficient secondary trading system of some sort of platform that would work. And it's very challenging, so it's way beyond what I can come up with a good idea for. But maybe some of you very smart PhD folks will tackle that and come up with something.
Well, thank you. We'll take time for maybe one or two real short questions. Yeah, Dwight.
There's been a growth in the private placements, and do you see this taking us a step back from some of the advances that we've discussed?
Yes, yes. Were you talking about bank loans primarily?
Yeah.
So, yes, issuers ought to have the full toolbox of different options when they need to fund an initiative. The problem is that going to the bank loan market because they don't want to deal with disclosure, or they don't want to deal with the financials, or they're worried about the SEC. I mean, those are all the wrong reasons to go to a market, a different market. The bank loan market is very opaque. There are no requirements for immediate disclosure. That loan might show up on a footnote to a financial statement in 16 months, but it is not helpful at all. But more importantly, the terms of bank loans are not disclosed. They're not known. And just like that small government, getting a fire truck, they can sign a bank loan with their local bank, but the priority of payments, the events of default, the acceleration provisions, I mean, these are very sophisticated instruments, and then, let's say it's a 5-year term, they might need to roll that over where they might not be available there in 5 years. So there are very, very significant consequences, and, is this going to be the next auction rate fiasco or disaster? I don't know, but there's a lot of issuance in that part of the market without a lot of data.
In the 2000s, I shot down quite a few direct loans on the grounds that there were default provisions that would give the lender, a bank, the right to call the loan on 30 days' notice anytime they wanted to, or because the loan would, it was unclear what would happen when the loan matured, what interest rate provisions were going to be. I thought that was way too risky for some of my issuers. But even in the 2000s, there was gravitation in that direction. They can be very risky loans. There's no excuse in my mind for these loans not to be disclosed promptly on Emma, other than the fact that 15C212 doesn't require it. And it's not just bank loans, there are also other lenders too.
Yeah. Hedge fund loans, any kinds of other indebtedness.
So with that, I think we will close the panel as we hit the time. We could continue for quite a long time, but I want to thank you all for coming today and sharing your knowledge about MSRB and 40 and the impact it's had on municipal